Good morning, folks. It's Andy Stautz at Stautz Law. I am back for another talk about an estate planning topic. And this topic is step up in basis for houses. So this is kind of a tax planning topic. And step up in basis is an important concept to understand in your estate planning because it's probably the biggest tax effect you're going to feel, or your heirs are going to feel, really. As you might know, and as I've talked about elsewhere, the current threshold for the federal estate tax is really high. It's like $15 million under the new law, and that's per person. So most people just don't have to worry about a federal estate tax anymore. And Indiana abolished its inheritance tax, getting to be a long time ago now, So for most people, it's kind of income taxes that they need to worry about, or income taxes for their beneficiaries. And so for a lot of people where the house is kind of one of the big assets in their estate, you got to say, okay, well, what's the tax consequences for my beneficiaries going to be if you prefer use a transfer on death deed? That's probably the most common device, or pass it by will, or put it in a trust. And the answer is usually there aren't huge tax consequences for your heirs. And that's because the step up in basis adjusts your basis in the house or in the real property from your basis to whatever the value of the house is at the time of your death. So it helps to talk about an example. Let's say you bought a house in 1990 for $100,000, and now it's worth $400,000. If you were to sell the house right now, you would owe capital gains tax on the $300,000 in capital gains. That's the $400,000 sale price minus the $100,000 of basis, the amount of money you put in to start with. Now, there is an exemption from capital gains on the sale of primary residences, which is $250,000 per person or $500,000 for couples. So for most ordinary people selling houses, they don't actually have to worry about capital gains taxes. But if you've held a property for a long time, or it's appreciated a lot, maybe you're getting kind of close to that, tax hitting, actually coming into play. But the step up in basis for the house would be if you have a transfer on death deed, you leave the same $400,000 house to your heirs, you die next year. Sorry to hear it. Your heirs have a $400,000 basis in the house. That means if your heirs inherit the house, it's worth $400,000. Their new basis is $400,000, and they sell it right away. They owe zero in capital gains taxes because there's been no gain, since that basis was stepped up, since it increased from your basis of $100,000 to the fair market value at date of death, $400,000. So even if there were no capital gains exemption on the sale of a primary residence, your heirs usually don't have to deal with capital gains taxes for an immediate sale. And that's kind of good for heirs who aren't planning to live in the house, because to get that exemption from capital gains taxes, you have to live there for at least 2 years. So for heirs who inherit a property and sell it right away, the step up in basis means there's $0 in capital gains taxes owed, and it doesn't matter that they don't get the exemption if they don't. Obviously, they could move in, hold it, and that's a new consideration. But the upshot of all of that is the step up in basis means inherited houses, inherited real estate is not going to be a huge tax problem for your heirs if they sell it right away. Obviously, if they hold it, different story. And, this is one of the reasons, by the way, and this will be kind of my last last topic, we're coming up on 5 minutes. One of the reasons you need to think carefully before making a lifetime gift of your house or appreciated real property is because then you won't get that step up in basis. So if you give the property away during your lifetime, the basis stays with it. But just a traditional transfer on death deed will trust you get the step up. Okay, that's all for today. It's a complicated topic, obviously, but that specific question comes up enough. I wanted to answer it. I hope it's been useful as an informational topic. And if you are doing Indiana estate planning and probate, I've got offices in Indianapolis and Greenwood, and I'd love to help you out with your case. You've got my contact information on the website and here on the end screen. So goodbye for now.